evening, everyone, and thank you for joining us today for what I promise you will be a very informative and enlightening program. My name is Holly Parker. I am a solo practitioner with HMP Law, and I'm so pleased to bring you today's program on behalf of the Beverly Hills Bar Association, Labor and Employment and Immigration Sections. Today's topic will consist of a comprehensive review of the Domestic Workers Bill of Rights, also known as Dwbr, Labor Code Section 1450 Exsec. During our presentation this evening, we will first discuss the labor and employment piece of it, which will include litigation and damages. And then we will transition over to the immigration portion, where we will discuss common questions about domestic workers' immigration status and how immigration and employment laws intersect. We are honored to have three engaging, very accomplished panelist speakers today. The first on the labor and employment side is Mr. Damian P. Delaney of Ackerman, LLP. He is a partner in the labor and employment litigation section. He's also joined by Ashley N. Bobo, an associate attorney with the labor and employment section as well at Ackerman, LLP. Before I get in, and then thirdly, the immigration portion will be moderated by Joanne Litt, who is the chair for the immigration section for the Beverly Hills Bar Association. And our speaker for today on the immigration side will be Nina Rabin, Director, Immigrant Family Law Legal Clinic at UCLA School of Law. Just some housekeeping items before we begin. The program materials you should have all received in an email link from the Beverly Hills Bar Association, and they've also been reposted in the chat. In addition, MCLE certificates will be mailed to each of the registrants individually following the program. If you don't receive that, you can reach out to the BHVA or to myself, and I'll make sure that you receive the appropriate email. So without further ado, we will start with the labor and employment section portion of our program. And then I forgot to mention that we'll leave about 15 minutes for questions. So please write any questions that you may have on either of the two topics in the question and answer box or the chat. And we will hopefully get to your questions and comments at the conclusion of the program. But we also want to be respectful of everyone's time. So I will try to ensure that we end promptly at 8 o'clock. So again, thank you for joining us. Okay, so I just want to give a brief introduction of the speakers for the labor and employment topic. Damian P. Delaney is a partner, as I mentioned, at Ackerman LLP. He is a seasoned employment litigator and advisor with more than 15 years experience helping solve employment law problems for clients large and small in a wide array of industries, including retail, hospitality, food and beverage, real estate, construction, engineering, manufacturing, education, and the like. His bio is very extensive, and I don't want to take up too much time, so please feel free to visit his firm website to learn more about him. But he received his JD at the Washington and Lee University School of Law, cum laude, and attended College of William and Mary and received a Bachelor of Arts. And he's admitted to the California Bar, as well as, it looks like, oh my goodness, almost all the districts, Central, Eastern, Northern, Southern of California, as well as the U.S. Court of Appeals, 6th and 7th Circuit. Thank you, Damian, for joining us today.
Thanks, Holly.
Next is, and I'm sorry I didn't do your bio justice, but I didn't want to, you're so accomplished. I try to just pick out the nuggets and let folks kind of follow through. And please feel free if I missed something that you wanted to highlight. Next, we have Ms. Ashley N. Bobo, who is also with Ackerman LLP. She's an associate attorney there. She attended the University of Southern California Gould School of Law and received her Bachelor of Arts from Harvard University. Ms. Bobo focuses her practice on employment litigation and counseling and represents employers and entrepreneurs in a wide variety of industries, including retail, manufacturing, hospitality, restaurants, airlines, healthcare, staffing, private schools, and the like. Ashley regularly provides in-depth and day-to-day advice to employers on employment law compliance and litigation avoidance, including advice on employee exempt and non-exempt classifications, independent contractor status, complex pay practices and policies, wage statements, and the like. Again, Ms. Bobo has a very extensive bio, which I encourage all of you, if you'd like to read more about her, to also visit the Ackerman LLP website. And without further ado, I will turn it over to Damien and Ashley to discuss the labor and employment portion of our program. And then, as I said, we'll turn it over to Joanne to moderate the immigration section. Thanks again for joining us.
Thank you so much, Holly, for that wonderful introduction. Good evening, everyone. As Holly mentioned, my name is Ashley Bobo, and I'm part of the Labor and Employment Practice Group in Ackerman's Los Angeles office. I am fortunate to be joined by my colleague, Damian Delaney, who will go into a lot of the nuts and bolts that we might see when we're faced with litigation brought under the California Domestic Worker Bill of Rights. But I'm going to get us started with some of the basics. And I appreciate Damian for pressing the button on the slide. So bear with us. We might have a slight delay when I make a request for a next slide, but we will try and keep it as seamless as possible. So next slide. We have to start with what exactly is a domestic worker. It seems fairly straightforward for most of us because we've seen it growing up our entire lives, but statutorily, it is defined as any service that's related to the care of a person in private households or the maintenance of private households. So we're thinking nannies, childcare providers, housekeepers, cooks, gardeners, anything that can really fall into the maintenance of a home would be included in domestic work. But the important thing that this law really serves to address is the fact that domestic workers can be divided into two categories, which is one, whether someone is a personal attendant or a non-personal attendant. And this is significant because the overtime rules and the way that you pay an individual will really depend on whether or not they are working to serve an individual while they're in the house, or if they're simply maintaining the home itself. Now, originally, when the Domestic Worker Bill of Rights was introduced, there was actually a really comprehensive set of rights that it was trying to extend to these in-home caregivers who were personal attendants. They were considering things as vast as uninterrupted 8 hours of sleep every night, paid sick days, paid rest days, guaranteed hours during which a domestic worker that's a personal attendant might be given time to themselves. But as it went through the channels of the legislature, it became pretty apparent that when it comes to personal attendance, it's difficult to mandate something like 8 hours of uninterrupted sleep time because the people that they're serving might need them during that uninterrupted time. And you're creating a legal liability anytime, for example, the caregiver might need to help someone change their dressings late at night. So by the time the law was passed, it actually was significantly streamlined, as you'll see on the next slide. And all that this Bill of Rights actually does in California is give overtime rights to personal attendants who previously were not included under anything. Prior to 2013, when the law was passed, as many of you may know, we have what is called Wage Order Number 15, which generally governs the wage and hour rights of individuals who are working in household occupations. So that would be something like a chef or a gardener, someone who isn't necessarily working to help a specific individual within the home would be covered under that typical Wage Order Number 15 that we're used to seeing. So the law does extend the overtime rights, and then it makes sure to outline the definitions that are important to us so that we know who this law is applying to. So to be a personal attendant, it's fairly straightforward, but it has to meet three essential elements. First, the individual has to be employed by a private household, or they can also be employed by a third-party agency that's recognized but then works within an individual private household. The second element, their duties have to be supervising, feeding, dressing a person or child. And it has to be for someone, if they are an adult who has some type of physical disability or mental deficiency wherein they do need supervision. And finally, the attendant's duties cannot exceed 20% of the total weekly hours that they spend working in the home. So non-attendant duties might include anything like making beds, house cleaning, cooking, laundry, really anything that goes beyond definitively assisting an individual with their person and their body would then stray into the area of non-attendant duties. And we want to look out to make sure that we're not crossing that line because it's going to extend a different type of overtime liability. Now, the law is also clear to outline who is not considered a personal attendant. And it does this because, as I'm sure many of you have experienced, there are plenty of situations that arise on a day-to-day basis where a family member might come into the home and assist someone who needs help. That person cannot, under this law, be considered a personal attendant and receive overtime. So it lists out specifically that an individual's parent, grandparent, spouse, sibling, or child cannot be considered a personal attendant for purposes of this law. You also cannot have someone under the age of 18 who is employed as a babysitter to a minor be considered a personal attendant. It also makes reference to what is referred to as a casual babysitter. That would be someone who doesn't necessarily babysit for you all of the time. They might have just helped you on that one night that you're trying to go out with your spouse. It's Saturday, you call them in at the last minute, but they're not supposed to be at your house on a daily basis, assisting you with childcare. Additionally, it also includes anyone who provides services to developmentally disabled through a state or regional center voucher program, and anyone who's providing childcare pursuant to certain childcare acts. So it does make these carve-outs to ensure that it is addressing those who are most in need of this law's protection, and is not going out to anyone and everyone who might come into your home and provide care at any point in time. So the law also makes sure to let us know who can be considered a domestic employer. And this will be really important when Damien gets into his section of the presentation, because it is extremely broad. It defines a domestic work employer as a person, and that can include corporate officers or executives. And it can be a person who directly or indirectly through an agent or any person employs or exercises control over the wages, hours, or working conditions of a domestic work employee. Now, it's important to emphasize how broad this is, because the law serves to make sure that if you're engaging the services of someone to come into your home, you will be liable for the pay that they are owed at any point in time. And it can be hard to envision what that looks like when it's happening at the time, because I think usually when people are put into these situations, they're quickly trying to find someone. They might find someone referred to them through a friend, and they'll say, "Oh, hi, I'm Ashley. I'm calling on behalf of my parent. Can you please come into my home 3 times a week and assist my mother with anything that she needs?" At that point in time, I'm running the risk of being the employer of this domestic work person, even if my mother is the one who's receiving the majority of the services. So the definition here is very broad, but again, Damien will go more into the nuts and bolts of that as we go through the presentation. Now, the law is very simple, as I said. It merely indicates that personal attendants are going to receive overtime pay at 1.5 times their regular rate of pay. Now, that's the same rate of overtime that we see in nearly every occupation, but the difference for personal attendants is that it's limited to hours worked in excess of 9 hours a day or in excess of 45 hours in a week. Now, as I mentioned, that differs from what we'd see from non-personal attendants who would be subject to the type of overtime that we're used to seeing in any other employment scope. And this is that wage order number 15 that I mentioned to you previously. And it's also divided between non-personal attendants who would be a live-in non-personal attendant or one who does not live in the home. So if the non-personal attendant were living in the home with the family, they would be entitled to overtime at 1.5 hours for any hours worked over 9 in a day, or the first 9 hours worked on the 6th and 7th consecutive day, and all hours worked over 45 in a week. And the difference between them and the personal attendants that are covered under the Domestic Bill of Rights is that a non-personal attendant, so like if your chef were to live with you, they would actually be entitled to double overtime pay, which would be 2 times the amount of their regular wage rate for hours worked in excess of 9 hours on the 6th and 7th consecutive day. So the difference there is, again, it's now after you hit that cutoff point, if you were a personal attendant, you would just continue to receive the regular 1.5 hours of overtime. But if you are a non-personal attendant, that then becomes double overtime that you would see in another type of occupation. And non-live-in, I won't read all of it just because I know that's not the key focus here, but I did want it included in the materials for everyone so that they could see. This is a very standard, what we're used to seeing for everyone. If you're working over a regular 40 hours, you're getting your 1.5. If you're working over 8 hours, you're getting your 1.5 hours of overtime. And finally, I just wanted to throw in a quick discussion on this case because it came up before the Domestic Workers Bill of Rights was actually enacted, but it did outline how much of a difference this law could have made had the individual been employed during that time. So this was a live-in personal attendant. Her name is Lide, and she was working with 2 autistic sons of these doctors that lived in San Diego. Now, she worked with them all the way from 2002 until April of 2014. So 3 months of her employment were covered under this law, but the first entire 12 years that she was there was not covered under this law. But they still had an issue here because they were paying the personal attendant $3,000 a month. All personal attendants, even prior to the Domestic Worker Bill of Rights, were entitled to at least receive the minimum wage. She was not receiving the minimum wage despite having that $3,000 a month. So when they went to court, the family ended up owing her over $200,000 in back wages for the amount of time she spent working with them as a personal attendant. And they didn't realize that they had miscategorized her as a personal attendant. They were treating her as a non-personal attendant. And so the family really ran into a lot of issues here. And it just goes to show that if you are not purposefully looking at the duties that your individual is conducting, you might end up owing them a lot more money than you were paying them. And even though $3,000 a month might have seemed like a lot to the family at the time, she was not receiving her full minimum wage. And so I will give you that little tidbit as a transition to Damien, who will get started on those big risks that you can see in litigation. Thank you.
Thanks, Ashley. And I think the Lide case is actually a really interesting transition to what I'm talking about, because I think it's stories like that kind of make the hair people's necks stand up. Like, oh my gosh, we thought we had a very generous compensation agreement with this person who's coming into our home, and now they've turned around and they've sued us and gotten an award of $200,000. And in some respects, you feel like this is kind of the story of wage and hour litigation for unwitting employers too often. So I one of the things I probably don't love about my job, but I feel like I have learned how to do it is how to scare people. And I don't like to think of it as scaring people. I like to think of it as empowering people with the knowledge and the tools to be able to navigate what's a pretty complex regulatory sea we have in California. When we put the Domestic Workers Bill of Rights, I think, in context with the legislative and case law developments in California really over the past probably 20 or more years, is the labor code continuing to sweep people into the status of employees. Just in the last 3, I guess, years here in California, we've seen a very directed targeting of the gig economy. And I'm going to be talking over the next few minutes about how some of those legislative changes and case law changes relating to the gig economy also have a little bit of impact here in the Domestic Workers Bill of Rights context as well. But I think it's also important just in context to see the Domestic Workers Bill of Rights as part of that ongoing policy direction in California to move people out of the gig economy, out of the underground economy, and into employment status and into the rights and privileges that employees have under the labor code. So I'm going to, got a little ahead of myself there. I'm going to try to give you a context today of the risks that come with having domestic workers working in your home. And that's the risk that an individual homeowner, household head or family member of someone who relies on an in-home caregiver, as well as the risks that are out there for businesses that are providing opportunities through referrals or through placements of domestic workers in people's homes. Some of those risks overlap. Some of them are divergent because those entities and those individual homeowners or family members have different concerns. But you can kind of see how those risks overlap. Sometimes they dovetail with each other, and I think we can learn a lot by looking in both contexts. There's not a lot of cases that deal with the Domestic Workers Bill of Rights itself in the context of the Domestic Workers Bill of Rights. The lead case that Ashley just told you about was one of them. The other one is Duffy versus Tenderheart Home Care Agency, which I'm going to spend a few minutes talking about. And in that case, the First District Court of Appeal held that the Domestic Workers Bill of Rights defines domestic workers as employees and broadly defines domestic work employers to include anyone who controls the wages, hours, or working conditions of the domestic worker. That latter concept I'm going to keep coming back to during the presentation. So the client and the agency are by law employers. In Duffy, we had the scenario which California judges hate. Everybody is trying to run away from being this person's employer. The agency says that the caregivers that it was placing in people's homes were independent contractors. They had an independent contractor relationship. And they sought to apply the Borrello test to say, we don't control them. They're able to work for other agencies, and they're able to refuse shifts, and they set their own hours, and they negotiate their rates. And it was sort of true, but they made the argument that they could negotiate the rates with the families, and there was all this freedom, and hey, we're very hands off. And in Duffy, the court pointed to the DWBR and said, well, no, the legislature has said here in this statute, adopting the Industrial Welfare Commission's language, their wages, hours, or working conditions, which comes out of the wage orders. The legislature knows what those words mean. And it really meant it when it said anybody who controls wages, hours, or working conditions is an employer. So guess what, agency? When you go out and you set rates, and really in the case of Tenderheart, the client would pay Tenderheart. Tenderheart would take its cut, and then it would pay the caregiver the rate that Tenderheart had negotiated. And Tenderheart says, well, they could always go to the client and ask for more money. But the court said, well, yeah, that may be, but you're still exercising direct control over the wages, hours, and working conditions of the domestic worker. Now, Duffy comes in that the little window that happened between the Dynamics decision, which first introduced us to the ABC test in California, and AB5 when the legislature codified. So at that point, what Duffy was looking at was, does Dynamics apply to this relationship? And I think if we're thinking about, or if we have questions out there in the audience about, what does AB5 do with domestic workers? The answer is not much. So I want to deal with this and push it to the side. AB5, for one, in its plain terms, says that any extensions of employer status or liability set forth in the labor code and other provisions are not affected by ABC. So because the Domestic Workers Bill of Rights says anyone who controls wages, hours, or working conditions is an employer, then we don't look at ABC for domestic workers. And then later, a year later, we get AB 2257, which patches some spots in ABC where there were the legislature determined to refine or create some additional exceptions. One of those was for referral agencies. And so you may be asking the question, oh yeah, I remember there was that referral agency exception in AB5. Does that apply here? You have to look at what the job is. I think in most cases, it probably doesn't. And you're probably still going to look at the Domestic Workers Bill of Rights. But the referral agency does refer to minor home repair. So I suppose if you have a handyman who comes and fixes that drawer in the kitchen that sticks, yeah, you probably can avoid the Domestic Workers Bill of Rights there. Errands, so, you know, if you hired the kid next door to, you know, run and deliver your mail, to take your mail to the post office or something, you're probably okay. Dog walking. I imagine most people that have dog walkers work through a referral service to identify dog walkers. Dog walkers are potentially in the exception. Pool cleaning and yard cleaners, your gardeners, your landscapers may also fit in the exception. But within those statutory exceptions, we don't have time to, and it's a little off topic for this panel anyway, so I want to spend a lot of time on it, but those exceptions only apply if the worker still meets, it's like a 7 or 8 point test in the statute beyond being in those job categories.
Wow.
So we've already established, through Ashley's part of the presentation and what I just said a few minutes ago, that domestic workers cannot be classified as independent contractors. So what does that mean? What should domestic workers be getting if they're supposed to be employees? Well, as Ashley said, minimum wage for one. And on top of that, they're entitled to receive overtime according to the wage order or what is stated in the Domestic Workers Bill of Rights itself, depending on whether a personal assistant or non-personal assistant. So that overtime for 8 hours and time over 8 hours and time over 9 hours. Many people who engage domestic workers, particularly if they do it informally, not working through an agency, will negotiate a daily rate. Or like in the lead case, it may be a monthly salary. those types of arrangements are risky because domestic workers are considered to be employees, and because they're not exempt from the wage and hour requirements of the labor code, the overtime requirements of the labor code. That means you have to keep you have to keep records of their time. You have to track their time, and you have to pay them according to the time. Looking backwards, if you have or if you've worked with a domestic worker who was working, who's receiving a daily rate, a housekeeper who comes in and you pay $300 for the day, that can be reduced to an hourly rate by applying the FLSA standard for calculating the regular rate of pay. Just take all of the compensation that was paid in the work week and divide it by the number of hours that were worked. And that gives you what the person's quote unquote regular rate of pay is. So you can take that daily rate, however many days they worked, and divide that by the number of hours that they worked to get the rate. And then you have to figure how many of these hours exceeded the overtime requirements. Did my housekeeper come and the daily rate was supposed to be for the day, but she stayed 10 hours instead of 8? Then I need to take that hourly rate, multiply it by 1.5, and pay the housekeeper overtime for that time as well. There's also a real issue with what happens, and this is maybe not as big of an issue with a live-in domestic worker as a non-live-in domestic worker. You can envision the situation where you hired the nanny to stay with the kids for the long weekend. You went to Cabo with your spouse for your anniversary, and the nanny is staying there over the weekend, and your flight gets delayed, and you're going to have another night in Cabo, and you're not going to get back to this when the nanny has to continue to stay. Well, how are we paying the nanny for her sleeping time? If she's an employee in California and she's not live-in staff, it's very likely that the holding in Mendiola v. CPS Security Solutions, which is a 2015 case, applies here. And that's a situation where you have to pay her for all the time that she's asleep too. And that's that's a bitter pill for even big employers to swallow. But for a household, that can be quite expensive. One of the other things I wanted to spend a little bit of time talking about are the record-keeping requirements in the labor code. And an employer has an obligation to not only track workers' time that they worked, but also to pay them for all the time, but also to produce an itemized wage statement that has 9 specific categories of information that are set forth in Labor Code Section 226A. All of that information has to be provided to the employee at the time they're paid. And they have to retain those records for 3 years. And they have to produce them to the employee if a demand is made. So a lot of small businesses, large businesses struggle with this sometimes. For me, thinking of this from the perspective of an individual, these are highly technical, very difficult rules to comply with that, again, the sweep of the Domestic Workers Bill of Rights bringing domestic workers into the labor code in a very clear way, is going to create that kind of burden on individuals who are employing domestic workers. And we spent a lot of time in my world talking about meal breaks and rest breaks, and whether it was before the 5th hour, whether it was a full 30 minutes. The California Supreme Court told us earlier in the year that we can't round the time on the lunch break because it's got to be exactly 30 minutes. All of those requirements, ensuring that that person gets the breaks, that they get them in a timely fashion, that they're fully relieved of duty during the breaks and are able to enjoy the breaks and not getting interrupted by your children or by the neighbor or by you. That they're able to enjoy the breaks. All of those requirements, are going to come along with employee status. And if you were misclassifying the person as an independent contractor, and treating them as an independent contractor, or not treating them as an employee, then you run the risk in the absence of records, in the absence of an hourly rate, in the absence of providing meal breaks and rest breaks, that these may become things that you're liable for if the person sues you. And then finally, before I move to the next slide, just the act of misclassifying someone as an independent contractor in California potentially carries a statutory penalty of $5,000 to $15,000 per violation. So now let's talk about joint employer liability. And that broad definition of joint employment in the Domestic Workers Bill of Rights very consciously wants everybody who is involved in directing or paying or setting the time, the schedule for the domestic worker to be an employer. And you can see the policy reasons, or we can imagine the policy reasons for it, mainly being, let's make sure if this person has a wage claim that there is a pocket we can reach in to compensate this person. So we're going to sweep in, certainly sweep in agencies, especially in the notion that somebody who might, in an illness, at the time they hired the employee, they had money. At the end of their illness, whether it ends through them passing away or ends through them, entering some kind of assisted living facility or something, by the end of this, they're indigent and they can't pay that person. Well, now that this employee has a claim against the agency that referred them, at least, so they can, there's another pocket we can reach in to get the person paid. But the thing that I want to mostly focus on right now is how this plays out for the individual, especially in a context where there's not an agency intermediary, where there's just, what happens among people. You call your neighbor, your friend from work, you say, hey, my mom's really sick. I need somebody to come in and stay with her during the days because I'm working at an active law practice and I'm too busy. Who can you recommend? And you get that referral, and you, as the child, negotiate with this person. Maybe you initially pay them, or you take some kind of responsibility for running this relationship for your mother. You potentially make yourself a joint employer. So what does it mean to control wages, hours, or working conditions? And I'm going to get right up in front of it and say the law is not clear. I've got two cases, one of which, this Medina versus Equilon, was decided in September of 2020. And this is new stuff. Both of these cases, Medina and Ochoa, are not domestic worker cases. They're out of the franchise context. And, you see Medina versus Equilon. Equilon is a small franchisee with a handful of gas stations, but behind Equilon is Shell Oil. And obviously a smart plaintiff's lawyer wants to get after Shell Oil because who knows if this LLC that only has a handful of gas stations has any money, but we sure know that Shell does. So can we get after Shell as a joint employer? And similarly in Ochoa, again, a smart plaintiff's lawyer is facing a small franchisee, but he has McDonald's in the background, and he knows if he can get into McDonald's pocketbook that he's in a much better position. So what do the courts say in these situations? So in Ochoa, which was a case from 2015 in the Northern District Federal Court in California, the court found that just because McDonald's had influence over the franchisee and how it operated its businesses, including, by the way, influences on employment-related issues that had a tangible effect on wages, hours, or working conditions, that was not enough to establish joint employment on the facts of that case. Instead, what the Ochoa court said was there needs to be direct control. McDonald's has to really be reaching in and controlling human resources, controlling compensation decisions, controlling hiring, firing, scheduling, those types of things that bear on wages, hours, and working conditions. But McDonald's is more kind of like the ringmasters, and this is what our stores need to look like, franchisee go execute. And so the franchisee has operational control. And in Ochoa, operational control is what's key. But in Medina, we see the courts, and this is a California Court of Appeal decision, again from last month. We see the court take a little bit of a different angle. In that case, it's really interesting. I think it's got a kind of interesting factual parallel with domestic workers, which is that Shell Oil was reaching into the franchisees' bank accounts and putting money there and taking money out. And the court said, well, okay, if you've got access to the bank accounts, that's a factor that shows you can indirectly control wages, hours, and working conditions. So Medina seems to relax the standard. Now, we may need to wait for the California Supreme Court to come in and clarify all this. But I read Medina in the context of the scenario I just described, which is we've got to get mom a daytime caregiver because I can't do it because I'm working. And I, as the child, am moderating, managing, in some respect, influencing the work conditions, the employment or relationship between the caregiver and mom. In that scenario, even if you're not writing checks, but almost certainly if you are writing checks, you could be potentially positioning yourself as a joint employer with mom. And if mom dies, you may be on the hook. If mom becomes indigent, you may be on the hook. So it is an important thing where people have to be quite careful, I think, in these, particularly I think in these elder care situations, to make sure that they're protecting themselves as best they can from the potential of joint employer liability should the relationship deteriorate with the caregiver. So real quickly, let's just walk through kind of in summary what the risks are for agencies. Obviously, the improper independent contractor classification is a big thing. One would think that after this law has been on the books for 6 years that most agencies out there know, okay, they've got to be W-2s, but again, that's a big one. But then you've got lack of control issues. Again, if you're trying to do things like make sure you've got accurate timekeeping, make sure that people are complying with meal and rest breaks, but yet you're sending employees out into the client's home, and the client is dictating what's happening from the start of the shift to the stop of the shift, then as the agency, you're surrendering a little bit of your control over wage and hour compliance. Time rounding, I think I mentioned it very briefly to get to this point, is another fairly significant issue in this area, because a lot of these employees are working with paper timesheets and they're just writing down start at 8, stopped at 5, if they're writing anything down. And so agencies, especially larger businesses, are going to be expected to know what the rules are in California. And if they're having people work in a manner in which they are not recording their time accurately, or they're, shaving off a little here, shaving off a little there, that could create exposure. I should say time rounding has not been totally disapproved in California yet, but it is very much on kind of probation. And I would not be surprised to see time rounding, totally thrown out by the California Supreme Court in the next 5 years. I would not be surprised. One more thing, and I have a mention here of varying hourly rates. That's just that really is an administrative thing that large businesses just have to get right. If you've got caregivers that are going out there and they're working at different rates of pay, then somebody in your payroll department needs to know how to do that regular rate computation correctly to make sure that people are paid right. So finally, the big thing I wanted to spend 30 seconds on is the risk of class actions and PAGA claims, because I think that's really where the litigation, when there are the agency relationships, that's where the litigation is most likely to play out, because obviously smart plaintiffs lawyers are not going to spend a whole lot of their time targeting individuals, especially if they're not high net worth individuals. They're going to get their bang for their buck for bringing these cases. So they're going to go after agencies that have lots of people that are out there doing this work, especially if there are common threads that could support a class action or a PAGA representative action. Again, if you're an agency out there that's still treating these people as independent contractors, you're just waiting for, you're essentially sitting there waiting for the class action to come. And similarly, in some of these issues, if people are time rounding or if people are not accurately keeping their time in the stores, if they're not taking, or I'm not in the stores, excuse me, in people's homes, if they're not getting breaks as they're required to under the labor code, then there's some risk that could turn into a large representative litigation matter. So then what do we do to avoid risk? Well, obviously the first thing is comply. That's easy to say. So how do we comply with the law? What are some things we could do? One is consider, and there's pros and cons to this as well. Consider using something like a mobile phone app or a computer software program or something for people to record their time, so it's being recorded electronically instead of on paper timesheets. And that improves accuracy and it creates a record in real time that is far more reliable than a paper sheet. But watch out if you're going to have a bring your own device policy, you're going to have people use their own phones. There's lots of issues to that. The big red flag, of course, is expense reimbursement. If you have employees using phones for business purposes, and this applies to domestic workers, whether they're coming through an agency or they're working for you directly, if you have them using a phone, you should either provide it or you should be paying them a fair reimbursement for the business use of the device. But BYO devices or BYO policies raise other issues relating to employee privacy, as well as confidentiality issues, wage and hour issues of making sure that people are being compensated for time they're working when they're not in working hours, or when they're supposedly off duty, but they're checking things on the phone. That could be its own entirely separate topic, but it's something that I think requires a thoughtful approach and probably consultation with counsel. Each pay period, agencies should have their domestic workers reviewing and editing their time cards in the moment, making sure that they're accurate rather than waiting for the lawsuit. You're like, oh yeah, I didn't get paid for these 15 hours back in March of 2019. Well, how are we ever going to resolve it? So have people review their timesheets, that pay period, that work. Meal and rest breaks. Consider in your contracts with your clients saying our caregivers will receive breaks at these intervals, and the breaks will be scheduled. You're asked when your person takes a break to not to allow them to take the break and to not impose requirements on them or expectations on them, or to let them be fully relieved. Implement training in the onboarding and the ongoing relationship with people, so that they know when they go out there that they're entitled to get the breaks, and this is how they should go about doing it, and this is what they should do if the client gives them a hard time about it. And then also, this is we tell every employer, regardless of industry or what they do, that they should always consider just automatically paying the meal break premium whenever somebody doesn't get a break for a business reason. It's just it doesn't cost you as much. It certainly doesn't cost you as much as a class action. And it definitely goes a long way toward reducing the risk of class action. Finally, arbitration ? And I should acknowledge that the Ninth Circuit has given something of a green light to AB 51, which purports to make it illegal to enter into our employment arbitration, or let me say a mandatory employment arbitration agreement. So as of today, an employer pushing out an arbitration agreement that's not out there already is taking a risk. But that said, if a higher court throws out AB 51 down the road, or if for some reason AB 51 is changed, or there becomes some way that employers can figure out how to do arbitration agreements in a way that is not illegal, then they can use class action waivers as a way to try to avoid class actions. Just keep in mind that PAGA is immune to arbitration agreements, and you can still get hit with a PAGA case.
Well, thank you, Damien. Does that conclude your presentation?
I know I've probably gone over a little bit. I just wanted to, let me see if I can just actually jump ahead one more slide, and then I think Ashley will wrap up. But what can individuals do to reduce their risks? And those risks, I think, dovetail with the agency risks, but of course, they also have a lot to do with the fact that individual people and individual households don't have the same kind of financial wherewithal that business does. So consider using an agency to take care of all these problems for you, and then look in the agency contract to see how you will be protected by the agency if for some reason there ends up being a wage claim. In your home, invite workers to take breaks, remind them when they should take breaks, and perhaps especially if you're directly employing them, just simply keep a record of it. And along the same lines that I recommended for business employers, try to keep the records. Avoid flat fees and salaries. Always better to just pay people by the hour. A big one is on your homeowner's policy, make sure you have a workers' comp rider. Because that's another thing you don't want to come bite you. If you have your nanny stumbles on a Lego and sprains her ankle, you'll want to have that workers' comp policy. And finally, my last thing before I'll let Ashley take us out is be kind to your employees. One of the best preventive tools that we find for employers is that if you're a good boss, you treat people respectfully and they're happy and they feel fulfilled by their job, then they are much less likely to sue you. So with that, I'll let Ashley wrap us up.
Thank you, Damien. So obviously we've discussed a lot about the California Domestic Worker Bill of Rights today, but I did want to talk a bit about what's going on a nationwide scope, because this topic is very much still in front of our faces right now, and there is probably more to come. So next slide, Damien. Even though we have the California Domestic Workers Bill of Rights, on a nationwide basis, there's still a lot of issues that are being faced by domestic workers. And some of those statistics that kind of leap out to you immediately are the fact that only 16% of domestic workers in the country have a written agreement with their employer. I cannot stress enough that having something in writing is the way to go here. It will really serve to protect you and your interests down the line. If you have something in writing, it's so much easier to hash out litigation if you do end up in that situation. Over 1/3 of domestic workers in the country do not get meals and rest breaks at this time. And 81% of domestic workers get no pay if their employer cancels on them with a lack of notice, or cancels on them when they show up that day even. So the legislature is currently trying to find a way to address all of these problems. As I mentioned, the California Domestic Worker Bill of Rights started off with a very long list of things, and ultimately was only able to say, we can give you overtime. But next slide, Damien. In July, there was new legislation introduced once again. This bill has come up on the national level. Previously, it was first addressed by, at the time, Senator Kamala Harris, now Vice President. And if passed, the National Domestic Worker Bill of Rights will try to ensure that there is paid sick leave for domestic workers. will extend civil rights protections. So it will address the fact that they cannot be retaliated against, that they cannot be discriminated against, that they cannot be subject to harassment. It will afford them the right to take meals and rest breaks definitively. And it will require that a written agreement be in place that lists out the roles and responsibilities of the domestic worker in the household. And finally, they do plan to try and have a piece that will focus on those last minute cancellations that I discussed, because that's one of the biggest issues that we see is you schedule the domestic worker to come in, and then all of a sudden, I canceled my trip. I'm not going. I'll actually be here. And they're left without an entire days of pay that they were expecting. So on a national level, we're going to keep monitoring it. This just got introduced this year in July. So it's probably going to take another 10 years before we actually see any action. But it is out there, and it's likely that some of these things will become a lot more permanent outside of California in the future. Thank you.
Awesome. Thank you so much, Damian and Ashley. And sorry, Damian, I heard the pause and I wasn't sure if that was my cue to jump back in. So I didn't mean to cut you off. So my apologies. Wow.
Nope.
So much information. We already have 4 questions, which, as I mentioned at the beginning, we'll save to the end. We'll save hopefully, 10 minutes to answer those questions. But if you have access to that, I think they're all labor code related. Some really good questions. So I hope we get to all of them. And if we don't, we will have the panelists follow up and with the person that asked the question to make sure it's properly answered. So without further ado, I'm going to turn over the program to Joanne to introduce our immigration law topic speaker. Again, Nina Rabin, and take it away, Joanne.
Hi, everybody, and thank you for staying with us for this very comprehensive, detailed, but so useful presentation. We're lucky to have Nina Rabin with us today. And Nina is the director of the Immigrant Family Legal Clinic at UCLA School of Law. She was previously the clinical professor of law at University of Arizona, James E. Rogers College of Law, where she served as a director of the Immigration Law and Policy Program. She has authored articles and reports on the consequences of immigration enforcement for children and immigrant families, working conditions of low-wage immigrant women workers, immigrants' parental rights, and the treatment of women fleeing gender-based violence in immigration detention. And she has been published in many prestigious law reviews, and we are so lucky to have her to round us out on this very important topic. And I'm sure everyone who's ever hired a nanny, or I think ever since the 90s with the whole Dwbr nanny gate situation, I know that I just remember hearing about that since I was little and being like, oh my God, every time somebody said nanny, it was like illegal, illegal, what did that mean? And all of a sudden I remember everybody's gardeners, and it became a thing. So I'm very excited to have Nina help us clear this topic for us today. Go ahead, Nina.
Great. Thank you so much. And thanks for inviting me to join the panel. I thought I would start by just explaining a little bit about my background and perspective on these issues. As Joanna mentioned in her introduction, I work at UCLA School of Law and direct a relatively recent addition to the clinical program there that's called the Immigrant Family Legal Clinic. We're actually based on the site of a large complex of public schools. Some of you might be familiar with the RFK Community Schools. It's a huge campus right in the middle of Koreatown. It's where the old Ambassador Hotel was and is a tribute to RFK. And we are there to provide resources, representation, and community outreach and education to immigrants, students, and families at the school. So I come at the issue of domestic workers very much from having many domestic workers as my clients and as the parents of my clients. And, you know, a lot of times it's just what they're doing in the background when we're working on their immigration case. But we have had cases where we end up having T visas, which are for trafficking victims, based on the employment, the current employment that they are in or past. And, you know, these, I thought I would just very quickly sketch out one recent case we had to just describe how trafficking can intersect with domestic work really easily. So we had a recent family that came to our clinic, and we were actually working on their asylum cases, but soon learned that they actually were currently experiencing trafficking. They had, our main client, I'll refer to her as Anna, had been, you know, in a really dangerous situation in their home country in Central America. A kind of distant relative had said, look, I can get you a great job here. I can arrange for you and the kids to come, took care of the transportation and arrangements, a coyote to guide them. They came to LA and moved in the relative's home. And the relative said, okay, now you owe me for, you know, covering your trip here. And so I'm going to set you up with your work. And the work was largely domestic work, so cleaning, house cleaning, and some you know, construction work in various homes. And, you know, unfortunately, I think this relative was definitely not getting advice from our previous panelists. You know, it was not an arrangement with breaks or meal times or any of the things that, you know, you just heard about overtime. Instead, it was really just hours and hours, day after day of labor, you know, being sent to different homes. So when you think about this from the perspective of any of these homeowners, I don't think they would have had any reason to imagine that the person that showed up to clean their home was a trafficking victim. But that really was the reality. She was terrified to leave. She was routinely threatened with deportation or being you know, the police being called if she stopped working, if she tried to move out. And this went on for over a year before she finally did get kind of oriented enough to realize she had other options. So, so I just wanted to kind of sketch that out as, you know, kind of a worst case scenario, but not one that's all that uncommon for immigrants in this industry. So why talk about immigration status? This is just an overview of the themes I'm going to touch on. Why talk about it? How it might come up for employers. What types of immigration status you might encounter as an employer. And how you might be able to help immigrant workers who are who don't have legal status. Those are some of the questions that I thought might come up. And the first one is, you know, why even talk about this? Because, you know, you noticed in that presentation that it's nowhere in the Domestic Workers Bill of Rights. Immigration status has nothing to do with it, and that's, you know, obviously very purposeful. The idea, one of the crucial aspects of the law is that it applies regardless of immigration status, and we know that the disproportionate share of the workforce is foreign-born. And I just have a quick chart here that shows that if you look at overall in cross-cutting all occupations, you have 80% of workers are U.S. born, and in the context of domestic work, that goes down to 65%. So it's a really marked change. And if you look at house cleaners in particular, over 50% are foreign born. And this data comes from the Economic Policy Institute, which actually does it by state and city as well. And unsurprisingly, the LA numbers are even more dramatic when you look at the percent of foreign born. So it is, very likely to arise given that population. And, how it's going to arise for employers is, obviously most likely at the hiring stage. As we just got through hearing about, in basically almost all contexts, you are going to be considered the employer, or if you're an agency hiring people, you're going to be an employer. And along with that goes the requirement to confirm work authorization through the I-9 process. And so, a few quick thoughts here. I'm sure this is familiar to all of you, but you can't, that doesn't mean that you have to kind of elaborately scrutinize and ask questions about the documents that are presented. The only requirement here is that they reasonably appear on their face to be genuine and to relate to the person presenting them. So that's the standard of what you're expected to do when you check. And you can't demand specific documents. You look at the lists that are on the I-9 form, and as long as they either have one from list A or from B and C combined, then that is acceptable. So you can't demand that somebody has a legal permanent residency card, or that they show you their U.S. birth certificate. You have to accept any of the documents when you're doing this confirmation process. We just, as you heard, I have here, it's rare that domestic workers actually qualify as independent contractors. After this presentation, I think I can change that slide to say it's never the case in California. It sounds like, it would be highly unusual. The only time I can think of would be, if you are hiring a there's some small cooperatives where the cooperative itself could be, saying, okay, we're going to set you up with somebody to come to your home on Fridays, and they really handle everything about that arrangement. Then you have to truly not be involved in any of the decisions that are made about how the work is carried out and when it's carried out. In that case, you wouldn't have to confirm work authorization. The one other thing that I wanted to say on this topic is just that I think it's helpful to think about taxation, immigration, and employment. They're all intertwined here, but they're all also separate regulatory systems. And there are actually rules about not having information sharing. So you cannot, in terms of the tax information, if you have, from the worker perspective, the fact that they might be using an ITIN, an individual taxpayer ID number, instead of a social security number, that's not something that immigration is going to have access to. There are agreements between the agencies about not sharing information. So that's something I know from the immigrant worker perspective is very important, and something to think about also as an employer, that there isn't that kind of information sharing going on. But again, really important to be very clear that employment laws apply really without regard. So it's not a defense to anything that we just heard about, that somebody doesn't have work authorization. That is just simply not the way the law operates. So what kinds of immigration status might employers encounter when they're hiring domestic workers? I just kind of brainstormed a list. One thing to, of course, know is that just because somebody's foreign born doesn't mean that that they're undocumented, or that they don't have legal status, or even that they're not citizens. There's plenty of people that are naturalized citizens or lawful permanent residents. So, I think we're all very familiar with that living in LA, but it's important to know that. In terms of people who would be here on a visa, I think that is actually really not common in the context of domestic work. This is, one of many examples of how our visa, our employment-based visas are totally out of line with our labor needs. But there's basically no way to sponsor domestic workers. The really the only ones that would be a fit are au pairs for childcare, and then there's this very small group of personal servants for foreign diplomats that would be here on a visa. Other than that, there really aren't visas that would cover this occupation. But there are plenty of people who have work authorization who don't fit into these categories. And a lot of that is because there are so many people right now who are in varying stages of an application, a court process, a form of deferred action that all receive work authorization, even though they're not lawful permanent residents, they're not in a sort of long-term immigration status, but they absolutely do have valid work authorization. So that's just something to understand, that there's lots of people who would have valid work authorization documents who might be, I have plenty of clients who are seeking asylum who, are able to get work authorization after that asylum claim has been pending for 6 months, and they, they haven't won asylum because the cases are, so backlogged and delayed. It could be years before they do, but during that time, they are absolutely lawfully, working and employed. And the same goes for, DACA recipients have work authorization. Many people with pending various types of visas would have it. So again, the employer's role isn't to scrutinize or ask questions. As long as they can provide the work authorization document, that's really, you've complied with your requirements there. There are also people who are undocumented workers who are in this industry, and will and will be among the people that are hired. And it's really for employers to decide if they want to pay, how they want to handle that situation. Another question that employers ask is, how can I help? I found out that my nanny or my housekeeper doesn't have status. We've been employing her for years, and she, now all of a sudden told me she has some kind of crisis in her immigration case. I really want to help. Can I sponsor her? Can I help her? I think that the number one thing is to help get legal, high quality legal help for immigrants. There are a lot of claims and defenses, especially right now with an increase in prosecutorial discretion for people who are primary caregivers or who have lived here for a long time. But there's also a lot of notarios. There's a lot of really bad immigration attorneys. And so, I think that if that is something that employers want to help by connecting somebody with a high quality legal consultation, that's really could make a huge difference. And then, I think this is just so intertwined with all of the many dysfunctions in our immigration system. So I think supporting efforts to address that. We talked about the National Domestic Worker Bill. There's other immigration-related aspects to the National Domestic Workers Alliance, the work that they're doing that would help to give more immigration options to domestic workers, because part of what makes them so vulnerable is the lack of immigration status. And then if somebody is in the process of, if they are in court, an employer for a letter of support, that definitely can be helpful if that's something an employer is comfortable doing. So, there is another group that I encountered when I was researching this called the Domestic Employers Network that addresses this sort of intersection between immigration and employment from employers' perspectives that want to help their immigrant workers. So if anybody's interested, you can look into that. And I think I stopped with just enough time for the questions. So thanks.
Thank you so much, Nina. And Joanne, if you don't mind, I'm looking, we have about 10 minutes left in the program, and I'm looking through the question and answers and some questions that were placed in the chat. And it looks like they're primarily relating to the labor and employment topics. So to the extent maybe we can get one or two in, Ashley and Damien, if I can address them to either of you, and you can jump in and respond how you wish. Let's see. I like this one here. Okay, so this question says, it's been forever that someone has a cleaning person come to the house maybe twice a month, and by mutual agreement, there is no hourly wage, but a lump sum is paid for each such date, regardless of whether the hours vary from one cleaning day to the other. Is this type of arrangement no longer permissible, even if there is continued mutual agreement, and even if each cleaning day involves no more than 3 hours?
So that's an excellent question. Thanks, Holly. I'll take a stab, and then Ashley, if you want to jump in. I think that whether it's permissible, I think is fairly clear. I think that the state of California would view that as a contract that's against public policy, and that the intention of the legislature is that domestic workers be treated just like other employees are, who would be paid an hourly wage. I think with the hypothetical at the end of the question there as to whether the amount of time that is involved in the work day that's being paid out at a daily rate is going to answer the question. If you have somebody come into your home to work for 3 hours and you pay them $100 flat, you're probably okay, because you're not getting into an overtime situation, you're not close to it, and that you're paying them $33.34 or 33 cents an hour, which is well over minimum wage. So even though you did it as a lump sum, if you do the math adds up. The problem that you potentially face is that you didn't actually track the time. And if your housekeeper or whomever it is, landscaper, gardener, decides, last Tuesday I didn't work 3 hours, I worked 9 hours, then how are you going to prove that that's not true outside of having? So I think that's the real that's the real area where homeowners kind of take their risks in their hands by paying people this way, is that if for some reason things go south and that person tries to turn around and make a claim against you, where's the evidence that you need in order to prove that you that you comply with the law, treat the person according to your contract.
Okay, and then there's another question that says, are personal attendants entitled to meal and rest breaks under the Dwbr? If not, and the employee is contracted as a nanny or personal attendant, and then greater than 20% of his or her duties are non-personal attendant type duties, must the employee then be considered a non-personal attendant employee and be paid overtime differently and provide meal and rest breaks? Is whether an individual considered a personal attendant or non-personal attendant determined on a weekly basis or over a greater period of time?
Ashley, you want to try that one, or you want me to go first?
I'm thinking through all the separate parts here. I can start initially with the answer to your first question, which is, the Domestic Workers Bill of Rights does not make any entitlement to a meal and rest break for a personal attendant. So you are correct that they don't have that entitlement, although it's generally recommended that you should be giving someone that time just as a best practice, but it's not a requirement.
Oh, Ashley, I'm sorry to interrupt you. I just wanted to jump in though to throw out there also wage order 15, I think kind of is operating in this space as well. And the wage orders do have a meal and rest break requirement. And I also think because the DWBR makes domestic workers, even non-personal or even personal attendants, makes them employees, that the default rules under the labor code are there. And so I would say, I think you've got to comply there.
Right. Okay. And Joanne, did you want to lend the next question? Share the next question.
Okay, how is this law working out for California domestic workers? When this law came into effect, we moved my Alzheimer's father to Nevada rather than bankrupt him before he died. The caregiver lost the job.
I want to obviously express my my condolences to the questioner there on the loss of his father. I think this is an issue that we oftentimes hear from all manners of employers who are trying to figure out how to get through this regulatory environment in California and see like the cost of doing business here is too high because cost of labor is very high because of the rules here. I don't know, and Ashley, maybe you have a little bit more information. I don't know that anybody has actually tracked or done any kind of research on, are domestic workers getting less work because of this law than they were before. I kind of doubt it. And I doubt it because California is a big state. It's a big economy. And there's always a need here. There's always going to be children being born and old people getting old and sick and dying. There's always going to be a need for people to come and do these types of jobs. And the question is how are we as an economy, how are we paying for the work?
And I'll follow that by saying that, the Domestic Workers Bill of Rights, there is one piece to it that I didn't discuss just because it's not readily applicable to anyone here. But the law does require that the governor create a committee of personal attendants and domestic workers and representatives so that they can report back the effects that the law is having. Originally, when this law was passed, they weren't really sure if it was going to have any staying power. So it was originally set to sunset, I believe, in January of 2017. There was subsequent legislation that made it a permanent law. So one, I think we have to assume that things were going pretty well if they decided to continue with the law and that it was actually helping to do its job. But the committee is also renewed as well when the new legislation came in 2017. And they're required to keep collecting data on the effect of the bill, I think until 2025. If I recall. So I think right now there's no definitive answer that, yes, this is definitely working out and helping people, but there is the requirement that that data is collected, that it's reported on, and that eventually we'll know whether this law really did do its job. I do know that there was a study done, and I believe it happened in 2015. So it was pretty quickly after the law was passed, and maybe it didn't have enough time to go into effect. But at that time, it said that about 25% of California domestic workers were actually paid below minimum wage. So there's still that issue. And it's prevalent, but at least the recourse is available to the domestic workers now where they can go and file a wage claim and they can try and get that money back because of this law.
Well, I see we're at about 7:58, so that probably need to wrap it up. To the extent your question wasn't answered, either in the Q&A or the chat, please feel free to reach out to the panelists or myself or the BHBA, and we'll make sure that we forward your question to the appropriate panelists. But I would really sincerely like to thank everyone for attending this evening, for your attention. I really extend an extreme expression of gratitude to the panelists, to Damien, to Ashley, to Nina, to Joanne for allowing to co-monitor this program with me. Again, I want to thank the Labor and Employment section and our section chair, Jennifer Ostertag, as well as the Immigration section chairs, which is Joanne Litt, as well as Maggie Stewart. If any of you all have questions for the panelists, we'll put their emails in the chat, or if you want to quickly, panelists, let them know what your email address is. That would be great, but I'll stop talking. And Joanne, if you wanted to say anything else before we sign off. And I see Ashley put her email in the chat for us.
Yeah, I just wanted to thank all the speakers as well. That was so interesting. And I had heard about this thing, and I remember being excited that this Bill of Rights was coming into action. But then, of course, I sort of forgot about it and how it was implemented and how it was affecting people and, everything. So that was very informative. And thank you to all of you. And thank you, Nina, for clarifying such interesting nuances of trafficking and deportation. And it's such a messy, it's just a mess. All this is a mess, which just highlights all these areas are messy and I feel like rife for bad things to happen if you're not careful. So thank you, everybody. And
thank you.
Thanks for coming. And thanks. And you'll be getting your MCLE certificate, I think, right after this or within the next hour. So
that's correct. Thank you, everyone. Good night.
Thanks, everyone.
Good night.
Take care. Good night.
Bye.